Hi everybody, this is Jason Lindamood with the Lindamood Law Firm, where we focus on estate planning and probate law. And today I'd like to talk briefly about if we were to die and our will, assuming we had one, needed to be probated. And probate is a process that can, at least here in Texas, take a few months. How could our loved ones get access to some of the money in our estate that they may need for things that maybe we don't think about that often, like funeral arrangements or other situations where things may need to be paid before this probate process is complete? But before we get to that, if you have any questions about any estate planning law or probate law issues, head on over to estateplaninfo.com. That is estateplaninfo.com, and you can set up a time for you and I to talk. So, I wanted to talk about a few workarounds that if we were to think a few steps ahead, we may be able to at least partially solve this issue about not having access to our funds while our will, again if we have one, is going through the probate process. And one of the first things we could do to alleviate this problem is to add an adult child, or maybe an adult child or two, as an authorized signer on our bank accounts. And in many cases, this often works, but ultimately it's really up to the bank. And it's not common, but I've seen situations where banks will still freeze the account at our death, even if there are other authorized signers on that account, at least until they get a court order, because the court order will relieve them of any legal liability when they release the funds to the proper beneficiary. Meanwhile, again, we could be dealing with a situation where we are not only having to grieve the loss of a loved one, but if it's us in that position, we're also trying to scramble and handle some of our loved one's financial affairs. And unless we have a boatload of cash in our own bank accounts that we can use in the interim, in the meantime, then this can cause quite a problem. Another thing that we can do is go to the bank and complete paperwork so that we make our accounts payable on death to another person, such as a loved one, a child, a parent, a sibling, etc. This payable on death designation does not give anyone access to our account while we're alive, but only once we are no longer here. And even then, the safety net for the bank is that the people that we designate to get our funds from our bank accounts, they still have to provide our death certificate and also their photo ID to show who they are and to show that we are indeed dead. And that's a nice workaround that many of my clients have put in place just in case. So again, this POD, or payable on death designation, that we sign at the bank generally absolves them from any legal liability whenever they do release the funds to the designated people that we've appointed. And most of the time, the banks are going to be super comfortable with this because we've specifically relieved them of, once again, the legal liability. And when we think about it, that's ultimately what these huge multinational banks and even some smaller banks or credit unions are concerned about. A third way we can avoid speed bumps when our loved ones are trying to access funds from a bank account is to create what's called a living trust, which is a different type of estate plan than our typical last will and testament. And when we use a trust, we will retitle and rename our bank accounts into the name of the trust rather than in our name individually. And we will normally be our own trustee while we're alive. And then if something were to happen and we were to die, our successor trustee that we've named in the trust takes over at that point and can walk into the bank, show them the binder that has our trust documents in it, show them their ID that indicates they are who they say they are, and the accounts won't be frozen. And in a typical scenario, if I were to die, my successor trustee will produce that trust instrument to the bank for approval, and the successor trustee gains immediate access to all of my bank accounts, and then they can disperse the monies in those accounts immediately to the beneficiaries under the trust without having to go through that probate process that we spoke about earlier. They don't have to hire a probate lawyer. and they don't have to wait a few months to get a court order that would otherwise be needed if we simply had a will rather than a living trust. So that's a selling point for a living trust in order to avoid probate, but that's a different video for a different day, and I'll save that for future videos as we move ahead. But I wanted to share those different ways that we can gain access to bank accounts without having to wade through a probate process in the courts, which again could take a few months here in Texas. And just as an aside, probate in Texas isn't that long of a process compared to some other states where, believe it or not, the probate process could typically take a year, 18 months, maybe even 2 years in some cases. So we are fortunate compared to other states. It's still going to take a few months, but comparatively speaking, isn't too bad. Isn't too bad here in Texas. So nevertheless, there are definitely some workarounds where loved ones can gain access to our bank accounts and get some quick money in order to take care of the immediate things that we typically don't think about that need to be taken care of. And thinking about these things and going through the process of handling our business in terms of creating an effective estate plan is not only forward thinking, but it's definitely worth it so our family can deal with the practical realities of us not being around anymore with as much ease and simplicity as there can be, rather than even more delay and frustration. So that's all I have for you today. Once again, if you have any estate planning or probate issues that you'd like to discuss, head over to estateplaninfo.com. That'll take you to our website where you can schedule a time for you and I to speak. Once again, this is Jason Lindamood with the Lindamood Law Firm. Thank you for your time. Thank you for watching, and I'll talk to you again soon.